in a family court abuse and neglect proceeding, does the fact that the family court issues superseding permanency orders that replace the old orders, does that render the old orders not subject to review and appeal by the mootness doctrine? To find out, you have to read Matter of Joshua J. versus Westchester County DSS, but it's 48 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Joshua J. versus Westchester County Department of Social Services. The citation for this case is 2025 New York Slip Opinion 03010, published by the New York Court of Appeals on May 20th of 2025. The issue in this case is whether a mother's appeal to a permanency order that's denied for review by the appellate division as being moot, is that appropriate or proper, or should there be a blanket exception to the mootness doctrine for permanency orders? I'll explain all that in a few moments. As always, I link to the decision in the description if you want to actually read the decision itself. The background law that's helpful to understand and appreciate the context of this case is that in the Family Court Act, which governs neglect and abuse proceedings, where where children are removed from parents' custody and placed in foster care system or other situations where they live away from the parents. That is found in Family Court Act Articles 10 and 10A. Specifically in 10A, they talk about where if a child is removed from a parent and placed in foster care custody, there has to be there has to be permanency hearings every 6 months to determine what the goal is, if it's reunification with a parent, if it's adoption, if it's kinship, guardianship, different plans for what to do with the children once they've been removed from their parents. Those hearings have to take place. They're called permanency hearings under 1089 of the Family Court Act. They have to take place every 6 months. And the judge or court attorney referee, if that's agreed to by the parties, will have a hearing to determine what's going on. If DSS, if the Department of Social Services is properly doing what it's supposed to do with respect to the current goal and whether the goal should be changed, and that's addressed at the permanency hearing. But because it's addressed every 6 months, if they want to appeal it, you have to appeal it to the appellate division. And by the time the appeal is ready to be heard, there's usually a new permanency hearing new permanency hearing decision. Okay. The other thing you have to know is that there's a concept called mootness in the law. And in the law, a court does not want to address a decision, will not agree to address a decision that does not actually impact the parties. If the actual decision that's being appealed has no impact on the parties itself, it's called moot, and the court can deny hearing that appeal on that basis. Generally, and this is the quote, an appeal will be considered moot unless the rights of the parties will be directly affected by the determination of the appeal, and the interest of the parties is an immediate consequence of the judgment. So if it doesn't affect the interest of the parties, it's moot and can be denied a hearing. What are the facts in this case? The facts are that in 2018, the Westchester County Department of Social Services, DSS, initiated neglect proceedings against a mother of 4 children. And the mother, the basis of the neglect proceedings was essentially she left her 14-year-old child watching her 5-year-old child. Allegedly, the 14-year-old child fell asleep and the 5-year-old child left the house and was wandering the neighborhood. That's one situation. And the other one is that she had a 10-year-old, an 11-year-old and a 9-year-old, something like that, take the bus to meet her at work for lunch. And on the basis of these alleged actions, the mother was found to have neglected her children, and then they were removed from her custody and placed in foster care, where for the next 7 years, they were out of her custody, more or less. There was one trial return, which she was found to have more neglect, and they were removed again. But every 6 months or so, they had these permanency hearings. In 2 of those permanency hearings, she didn't agree with how the proceeding went, how it was adjudicated, the procedures and standards of law being applied. So she appealed. But by the time the appeal was ready to be heard and considered by the appellate division, there was a new permanency order, because every 6 months, there's got to be a new permanency hearing and new order. So each time those 2 appeals were filed, the appellate division denied her hearing on the permanency order, saying it's moot. And so now her appeal to the Court of Appeals is, this is not fair. I'm being denied any chance to appeal anything because every time I try to appeal, there's a new order that replaces the old order. So yes, the old order may be moot in the sense that it's been replaced, but then I never get to be heard on the issues here. And over 7 years, actually, some of her children aged out of even being in foster care. So they were no longer even, she lost years with her children as a result of these neglect proceedings and permanency hearings. Ultimately, the appellate division denied the mother's claims, saying they're moot. Goes to the Court of Appeals, and the majority here, there's a majority and 2 dissents. The majority here says the appellate division is correct. It's moot. It's moot because, by definition, the orders that are being appealed from do not have any legal impact if they're reversed because they've been replaced by a new order. Okay? And they denied the application by mother to create a blanket exception for the mootness doctrine because there's a mootness exception where even if it's moot, you can be heard. And the mootness exception is the court may consider the merits of a moot controversy where the controversy or issue involved is likely to recur, typically evades review, and raises a substantial and novel question. None of the issues raised here was a substantial novel question, according to the majority. So it's moot. The mootness exception does not apply. Mom's application for a blanket exception is denied. That's the majority decision. There is a dissent by Judge Wilson, and there's also a dissent by Judge Rivera. They both would have the court hear these things. Judge Rivera would apply a blanket exception. She thinks there should be a blanket exception here because the mootness there's a substantial question here as to whether they're being deprived of their ability to be heard on the permanency orders. And that's the case of Joshua J. versus Westchester County Department of Social Services. The ultimate holding here is there is no blanket exception. The permanency orders are made moot by subsequent orders. And unless there's some substantial novel issue being addressed, some new or novel issue that typically evades review, it will be moot and no exception will apply. And that's the case of Joshua J. versus Westchester DSS. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.